Welcome to Case by Case. We want to just take a moment and remind you that this content is intended for adult audiences. It is created for educational and informational purposes only. Viewer discretion is advised, as discussions may include references to real criminal cases, violence, and other sensitive and potentially distressing topics. While we strive to present every case with accuracy and respect those involved, the material may not be suitable for all viewers. Please proceed thoughtfully. And remember, if you need to take a step back, if you find something that concerns you, if you find it to be triggering and you need to take a step back, please do. You can join us whenever you're ready to come back. We'll leave the light on. Welcome to Case by Case. Today, we're going to do something just a little different. There was a new document by the prosecution, the state, responding to defense's motion in the Rex Heuermann case. I don't have the defense motion, but we can get really what we need from the state's response because it really does tell us what they were filing for the state to have to respond to. There were 9 issues. Some of them are not really contested. Some of them have already been taken care of, but there were, I think, 5 or 6 that were spelled out in the response from the state. Now, the filing is interesting because it gives us a pretty clear look at what the defense has been arguing and how the state is responding. This document is the state's affirmation and memorandum of law in opposition to the defendant's motion. In plain English, that really means the defense filed a motion asking the court to throw out certain evidence and challenged parts of the case, and the prosecution is responding point by point, which is what is required in court. So, one thing we want to remember as we go through this is just the state's side of the argument that we're reading from. The defense has got their own version of events, their own law, their own interpretation of the evidence. And that's really how the court system works. And eventually, each side paints a different picture, and eventually the judge decides which picture is legally correct and what the jury, if it goes to a jury trial, will be allowed to hear. All right, one of the things that was discussed was the grand jury minutes. And basically the defense said, hey, we want the judge to be able to inspect the grand jury minutes for signs of impropriety, problems that might be there. And this is pretty common in criminal cases. And the prosecution says there's no problem with that. So that's done. That's not even a fight. The next issue, though, is about Sandra Castilla. The defense is asking the court to dismiss the murder charge again involving her. They argued that the evidence represented to the grand jury was legally insufficient, and it seems like they indicated that there was a problem with the integrity of the grand jury process, which explains why they want those grand jury minutes to be reviewed. But one thing that the defense apparently kept putting forward, as evidenced by, it is storming here. One thing that the defense keeps pushing is that the prosecution's case relies on a single hair. And the state says, no, you're not looking at the whole picture. It's not a single hair. And so the prosecution says that the investigators recovered a male hair, there was a female hair, and there's an entire chart in the document laying out how many hairs were found on each body. And every one of those matched up to either Rex or his wife at the time or his daughter. So you can do the math. I mean, there's only one way that hair can get there. Either the person that it belonged to was in close proximity to the victim, or one of their family members or friends or people that lived in the home with them or rode in a car with them were close to the defendant, right? That's pretty much the only thing you can get from that. Because they found it on their bodies, underneath their bodies, in the tape around their hair, things like that. So it's not something that they found on a site somewhere. They found it on the bodies. The prosecution is arguing that the hair becomes important when you look at it alongside everything else, and that the DNA did several tests and it was, like 99.99%. That much of the population could be ruled out, but Rex or Asa or Victoria could not. So the prosecution's argument, really, when you look at it overall, they are not saying this case is built on one piece of evidence. They're presenting it as a pattern. In other words, if you looked at one victim in isolation, one phone event in isolation, or one hair in isolation, the defense might have a stronger argument. But the state says when you line up the cases, you start seeing the same things over and over. All the years through, you see similar phone behavior, similar burner phones, similar timing, similar locations, family members being away during the key periods, hair evidence connected to the defendant or people in the household. So the prosecution says the strength of the case is not in one event. It's across all of the events and all of these victims. Remember, there's 7 victims. Another issue that was raised was the John Bittroff question. Now, I don't remember if we discussed John Bittroff or not, but John Bittroff was charged and convicted of some murders that were not tied to this. But the defense asked for all the discovery related to the Bittroff investigation. And the way it works is that if the police find other suspects that they're looking at during the time, even if they ultimately don't go with that and they go with your guy, they still have to provide the defense with that information. Now, they didn't do it in Delphi, but they are supposed to do that. They are supposed to provide the defense team or the defense attorney with anything that they looked into that's closely related to the crime and could have possibly been, could have led them somewhere in the investigation. And the prosecution pushes back a little bit, and they say DNA testing excluded him as the source of the male hair on Sandra. And there's no forensic connection between Bittroff victims and the victims in this case. So the state's position is simple. We looked. There wasn't anything. The defense also really attacks search warrants. They say that they were overbroad. Now, what overbroad means, it's a Fourth Amendment argument. The Constitution protects people from searches that are too broad. Basically, the state can't go on a fishing expedition and say, well, I know he's done something wrong. We're just going to go to his house and we're going to see what we can find. Oh, we found drugs. It's not what we were here for, but we found drugs. That's not the way it works. And what the state is saying is, hey, that's not what we did. We limited it to what we were looking for. We put time limits on it, and we put location limits on it. They said it was tailored specifically to evidence connected to the victims and the time frames involved. Again, defense's interpretation is going to be different from the state's. And when you're representing somebody in a defense, in a criminal case, you've got to do everything legally in your power to give them the best defense. And that doesn't start on the day of jury selection. It starts way back in the motions, way before the trial ever even gets put on the calendar. Because the reality is, if you can get it knocked out or changed way back during that time, there's a better chance that it's not going to make it to trial. The phone evidence was huge. I didn't know before reading this that they had this much phone evidence. But let me try to explain it. What they detailed is Rex Heuermann, the defendant, and he is the defendant. He's, innocent until proven guilty. The defendant was buying burner phones. And then he had his own cell phone. So you had a number of burner phones, and each burner phone was connecting to a specific victim that was later found. And what they were noticing when they were looking through all this is that the burner phone was communicating with, let's say, Sandra Castillo. But then there was no communications going on during that time frame from his personal phone. But the personal phone was in the proximity. So, for example, if they looked at the burner phone billing records and showed that it was in the Massapequa Park area, and that burner phone was communicating with Sandra's phone, for example, during 7 to 9 p.m., for example, there were never, not once, never, in all of the victims and all of the phone calls, there was never a time when Heuermann's phone was used at the same time the burner phones were. But they were in the same location. So if you had another person, it would stand to reason that at some point through all these hundreds of calls, that person would, just statistically speaking, be on the phone at the same time as this one would be on the phone. But that wasn't the case. And they didn't just do it on Sandra. They went through all of them. In addition, they found new burner phones all the way up into February 2023. And the number of communications that he was having with sex workers was unbelievable. I mean, there was one set where it was 300, in 14 months, there was 300 different numbers. And then there were repeated contacts to 60 different sex workers. Now, I didn't see evidence in here about whether he met up with them or what happened. But one thing that really, well, I'll get to that in just a minute. Let me keep going on this. The phones appeared to move together. They were in a geographic area. So it's like he had them both in his pocket and they were moving together. Where one phone moved, the other one moved, right? And it was that way with each victim. So the phone that he was using to contact Melissa Bartholomew, the phone that he was using, the burner phone that he was using to contact her, was moving in tandem with the one that was belonging to him. Now, Melissa Bartholomew it's disturbing because when she disappeared, her phone was then used to make taunting calls to her family. You may have heard about that in the news. And those calls were made from Manhattan, and the defendant's phone records place him right there in that same area. But again, the prosecution says it's not just this one thing, it's this larger pattern. The Amber Castillo timeline. Now, this one's interesting because Amber Castillo had made a date with Heuermann, allegedly. And he showed up, and Amber and her male roommate often pulled a ruse where the roommate would pretend to be the boyfriend and would scare the guy off after she had taken his money. And that's what they did to Heuermann, apparently. And I'll tell you why we know it was him and all of that. Well, Heuermann texted her from the burner phone that he had identified with her and told her that wasn't very nice and that she owed him one, pretty much is what he said. Well, he did go back out with her, and she was never seen again after that. So when the police were in their investigation stages, they went to that roommate, who is identified as witness one in the motion, and they asked him, tell us about this person. Tell us what you know. And he told them about the ruse, and he described this person as 6'4" to 6'6", dark bushy hair, heavy set, and wearing some kind of glasses. He described them. And then he said, and he drove off in a first generation Chevy Avalanche, and he described it. And lo and behold, after they arrested Rex, that's exactly the car he had, that green, I think it was green Avalanche. And he met the description. And then at some point, after the arrest, the roommate got a text from a friend of his saying, hey, did you see who they've arrested? Is this the guy that y'all pulled that on? And he looked at the picture of Rex and said 1,000,000%, without a doubt. So when the police called him and said, hey, can you come down and talk to us? They asked him if that was the guy. And he said, yes, as a matter of fact, someone's already shown me this picture. And, yes, it's definitely the guy. So that was a positive identification, but it was not done in the scheme of, we're going to bring him in and show a lineup. I mean, how are you going to find a lineup with people that look like him? I mean, there's not a whole lot of people that are that tall, that look like that. I mean, I'm not making fun of the guy. I'm just saying he's got a unique appearance. So anyway, that is why the defense was attacking it, is that, you can't use that because that's not really a correct identification. That's not the way it should be done. And the state is saying that was not an official, investigation type of identification. So I don't know how that'll turn out. But their argument is that it could be unreliable because it happened after the arrest and the media exposure was there. And this guy clearly saw his face and he said, oh, yeah, that's him. The judge will have to decide on that one. That's going to be a tough one. I mean, because it is a fact that when people see things after the fact, police don't want them to do a lineup or an identification because they know that that's already in their mind. And once it's in your mind, memory is kind of a funny thing anyway. The defense challenged the DNA that came from the pizza box and all of that the police got out of the trash bin, public trash bin, in front of Heuermann's office in Manhattan. And, basically, this situation has been tried many times before, and the courts have always said, look, you cannot have an expectation of privacy, and that's the big issue. You can't have an expectation of privacy if you've put it in the trash and put it out into the public. That's just, you've put it out for strangers, essentially, to pick it up, being the trash service. So if you don't have an expectation of privacy, then you can't have privacy rights violated. I think the state is going to win on that one because that's really been a long-standing Fourth Amendment law, and that, collection of the materials in the trash, which they used to get his DNA, then they swabbed him and it matched. So that's why the defense wants to knock that argument down, and a good defense attorney is going to do that. You can't, if you ignore that, that's going to be a problem. All right, now we're going to talk about the 2019 burner phone. There's a burner phone that was activated in 2019, and then it was turned off in 2023, like February 23. But this is the one that I was telling you about earlier, had contact with at least 60 sex workers and had approximately 300 prostitution related numbers. Those are their words. Their words are prostitution related numbers. So I don't know if that's companies that provide it on the down low. I don't know, what that means, but my take on it is not communicating directly with sex workers, but communicating with people that can put them in contact with sex workers, and then having communications with at least 60 sex workers between 2019 and 2023. But in one 14-month period, like I said earlier, one of his burner phones contacted 56 different numbers over 300 times, and another phone contacted 61 numbers more than 220 times. Imagine that. Just imagine that. That's a massive amount of activity just to be contacting sex workers. And all of the disappearances that happened, I want to point this out, I forgot this earlier. All of the disappearances happened when his family was out of town, either out of country or out of state. So, and I told you about how he took that one phone from Melissa Bartholomew and called her family. Well, those calls stopped for the 10 days he was in Iceland visiting his wife and daughter and her family. And then the day he arrived back home and got back into Manhattan, they started up again. I mean, it is circumstantial, but it's a lot of circumstantial, right? A lot. Now let's talk about the Gmail account. See, it's worth it to read these filings. And I like to do these as podcast episodes because most people don't read them and they don't understand what really took place. And then rumors get started through Facebook and other places, not just Facebook, Reddit, everywhere. People just talking to one another and things get all misconstrued. So the investigators identified a Gmail account that was created in July of 2010. It listed the defendant's phone number as the recovery number. So we know that was his Gmail account. And it was frequently accessed from an IP address linked to his home. Now, an IP address is like the phone number of a computer. No, it's the phone number of where the computer is located. That's the best way I can put it. It stands for Internet Protocol. And what it is if you take your laptop to your buddy's house and you hook up to their Wi-Fi or internet, you're going to be assigned an IP address. And that is a unique identifier for your computer at that instance, at that location. No two devices on the network can have the same IP address at the same time because it would cause a conflict. One of them will get knocked off and it'll have to get a new IP address. So they know that he was using that Gmail account from a computer with an IP address at his home address, because you can look up an IP address and you can find out the location of that IP address that is in use for the device using it. So I'm going to stop there with the tech stuff. I could go on, but you know what? I don't want to confuse anybody, and some people hate IP stuff. But the account was used to conduct searches about the Long Island serial killer investigation and the missing women. Searching about true crime certainly does not mean guilt, because all of us probably do that. But the state's point is, if you're searching for all of these things, why haven't they caught the Gilgo girls? Who was found? He was even searching for pictures of the family mourning the missing one. That's just awful. But if you're searching for that on an address that you're trying to hide, if you're searching for that from a phone that you're trying to hide, that's an issue, because all of my true crime searches that I do when I'm working on this podcast, or I'm curious about a case or following a case, they're just done on my account on Google. I don't have any need to hide it. I certainly don't have any need to create something unique and try to hide it. So that's just one more little piece in this armor that they're building, okay? In this big piece of evidence that they're putting together. That's just one more piece. There was a defense motion. I don't remember exactly how this came up, but the state had a special detective that was familiar with sexual sadists and serial killers come in. And when they came in, he spoke to them about the likelihood that Heuermann would have trophies that belonged to the victims, and that they should look for those. And the reason he felt that way is because Heuermann was a collector. He was a trophy collector specifically. He went and he hunted wild game. And you probably had permits and things to do all of that. But he collected photos of him standing beside the animal that he killed. He collected, he took the animal to the taxidermist and put their heads on the wall, and they're made rugs out of them for his home office. So the point is, this detective's thinking, if this is our guy, he's probably got some trophies, and he may even have some pictures of the victims, because this is what he does. This is how he does. He collects. Well, the defense is arguing that, that's being used against him in the wrong way. And the state said, again, investigators believed they were dealing with someone who might fit the profile of a sexual sadist, and that's why they were looking at that in the search warrant. And the filing also mentions that the defendant owned nearly 100 firearms, and that's another collecting, collecting firearms, collecting trophies. And so the state says the issue isn't hunting. It's part of this broader behavioral pattern that we're putting together. Because this was a complex case. Anytime you've got this many victims and they have not been identified for as many years as that was, and there were so many issues with the investigation in the beginning days of this case, you're going to have problems that you run into, and you're going to have to go back and look at every little bitty thing. Now, this is interesting. The prosecution says they don't intend to use statements made from Heuermann in the trial, because they said the statements were self-serving, and if the defense tries to introduce them, the state says they're going to be inadmissible hearsay. So the state's not going to introduce them either. So I don't know how that's going to be ruled out on, because hearsay is one of those really complicated things. Hearsay is an out-of-court statement proved, an out-of-court, man, I know this backwards, an out-of-court statement made for the proof of the matter asserted. It doesn't mean it's got to be the third person over. It doesn't mean you told grandma and grandma told somebody else and now it's hearsay. It's based on if it's out of court and whether it tends to prove what they're saying. If I say I'm going to the store and someone tries to introduce the statement, Terry said she's going to the store, for that purpose to prove that I went to the store, that's hearsay. But if they say, well, Terry was kidnapped on the way to the store, and after we found her, she couldn't remember everything. So we're trying to show her state of mind, that when she left the store or left her home, she was headed to the store, and that's where she was picked up. I mean, that's just a loose example, but you get the picture that you can't use a statement that's made out of court to prove a point, because it's not evidence. It's inadmissible. Now, there's exceptions to that, but we're not going to discuss that. The defense also argued that the prosecution has not been turning over all the evidence. Now, if you followed any trials, you know you've got to turn over the evidence. The prosecution says, look, we have turned over every single thing we have, and we know what it means. It means that if we have anything else, we'll turn it over too. And the defense was asking for information related to former police chief James Burke. Now, if you listen to my previous podcast, you know that James Burke was arrested for murder as well, but they determined that he didn't have anything to do. No, wasn't for murder. Bill Bitroff was for murder. Burke was for, I think it was fraud things now that I think about it. But anyway, they wanted all the evidence related to, they want all the evidence, really. They want everything. But John Bitroff is one we didn't talk about. And John Bitroff was convicted of murder, but they determined it didn't have anything to do with the Gilgo case. And originally, I think they thought it did. And there's still a lot of people out there that believe that it did. But the defense is saying, hey, we want that evidence. Because think about it from the defense's standpoint. If you've got a possible other suspect, you want to go down that rabbit hole just like the investigators did. You might find something the investigators didn't that clears all this up and helps your defendant. Now, in Delphi, we didn't get to see that. We didn't get to hear that because she didn't allow that. But we should have been able to learn about other possible suspects. And it's not so that people can go on a witch hunt. That's not the point. They don't have to turn over every single person they ever talk to. But if they've got someone that seriously looked like they met it and they were going down this, this road to learn more about them and see if they're the ones that possibly committed this, that needs to be turned over to the defense. At the end of the filing, the prosecution supports its arguments with case law. And that's how motions work. Both sides are going to say, here's the case law that backs up why I want the court to rule in my favor. And then the other side is going to file a motion in opposition and say, here is the memo of law in opposition of this filing that you filed. And A, you've got the case law wrong, or A, that's not what it says, B, that's not what it says, or C, there's other case law that's more on point in our jurisdiction or in time or to the circumstances. There's a lot of case law out there. And the way that it can be used to back up your arguments in a motion depends on your theory of your case. So you will look, I still do a lot of legal research, and you will look for things that pertain to the issue that you are working on. And you will try to find things that on both sides, a defense attorney is going to be looking for things that support their argument, and they're also going to look for things that don't support their argument, because you don't want to be blindsided in court, in a hearing, or in a motion. You really don't want to look like a dummy that you just didn't follow through and get the latest case law. Because, cases get overturned, law gets changed, new law gets introduced. That's just how it works. I'm trying to think if I forgot anything else. So the defense challenges the warrants. They said they're overbroad. And just another point on overbroad. You can't say, I'm going to go in and just look for anything. You have to be specific in what you're looking for and the details of it and the time frame. You can't just camp out at their house for, an unknown amount of time and keep searching until you find something. You can't go on a witch hunt. That is not, that is, the Constitution says that that would be overbroad. You've got to nail it down to what you're looking for in some time and things like that. And the state says that's what they did. That's exactly what they did. But the defense is doing what the defense should do. They're challenging the warrants. They're challenging the DNA. They're questioning the phone evidence. They're suggesting that we need other records from other suspects because we want to go check that out too and see if something got overlooked. The prosecution say, hey, the investigation was thorough. But the reality is you got one man that's got burner phones. He's searching for horrible stuff on the internet in addition to the communications from the burner phones. Now, I didn't talk about some of the stuff that was in this motion that he was searching for, but it's some of the worst stuff. I mean, it's death, sexual crimes, and it's all to women. All of it that they mentioned was to women, but it's really bad stuff. I think they did mention in something that I listened to, or maybe in the bail application, that there were things that were related to people other than women. But it was all violent, and it was all death related. It was torture and brutality, even impalement. And it was so bad. And they know that that was done from that computer that his email was created on, that Gmail account. And they know that that's where it was done. And that is one more piece of this. So I want you to think about this in the totality of the circumstances, as lawyers always say. The totality of the evidence. What it is it's not the one thing. It's the burner phones. It's the lack of communication at the same time the burner phones are being used. It's with multiple victims, this pattern. The phones move together. If one's in Manhattan, the other one's in Manhattan. If one's in Massapequa, the other one's in Massapequa. And so forth. The crimes take place always when the family is out of town. Never when the family is home. Now, I'm going to leave you guys with a question here. You can join our Facebook discussion group and discuss this if you want to. It's in the link on this episode. Or you go to Facebook. It's Case by Case. Anyway, and you'll see our logo. But my question to you is, do you think there were other victims? Do you think there are other bodies that we've not found? Do you think there were other missing women that we don't know of? I did an episode on all of the missing women. There are a boatload of missing women in that area. Unbelievable amount of missing women. And some of them were sex workers and weren't reported. So there was no one really looking for them. And that's a very sad situation. And many times these predators go after sex workers for that very reason, because you don't have anybody chasing you down necessarily. Now, obviously, this defendant did not count on Shannon Gilbert's mom, Mary, because when Shannon went missing, Mary Gilbert stirred it up so much that all these other bodies were found. So Mary Gilbert was the mama bear that really opened every bit of this. And he clearly was not counting on that to happen, because nothing had really happened for all these years. And then suddenly she goes missing and the floodgates open. So my question is, do you think there are other victims? And do you think they are victims that have been found and not identified? Or do you think we have not found all the victims? Because we know that he did change some things between victims. They all pretty much were found in the area and there was a lot of similarities to the way they were bound and their hands and heads, off of them. But there were also some differences as well. And there was that planning document. If you don't know about the planning document, one of the things they found, in addition to his catalog of books by people like John Douglas and Mindhunter and other detectives and experts and people that have written books about crime and serial killers. One of the other things that they found was this planning document, and this planning document basically was learning from what he did before and making a document to remind himself, do this, do this, do this, get rid of hands and feet, get rid of head, make sure you have these tools. I mean, it's really an upsetting thing when you read through it and you know what it really means, that he was trying to perfect his method of killing. So I'm curious, I think there are more victims. I mean, you've got the first one's in the 90s, and then we know he was communicating with sex workers nonstop all the way up through 2023. So it stands to reason that there's a lot more than the 7. And I just don't know if we found them yet. And I don't know if they're in other cities that maybe he visited. My understanding is he went to Atlantic City quite often. I don't think he would have gone with his family to do any of this. I think it would have had to be when he's by himself. But again, I'm just speculating, and he is innocent until proven guilty in a court of law. So we are not saying that he did these crimes. We're saying that he's been charged with these crimes. So I would love to hear what you think. This is Case by Case, and thanks so much for listening.